said, gee whiz, if I'd have known that this person was going to get this kind of a sentence, I would have never convicted him of that serious of a charge. And I believe that in this particular case, if the jurors would have known this was 20 years to life and that somebody may go away for 20 years in a case like this, they may have considered manslaughter instead of second-degree murder. And there is such a fine line between killing by emotion and killing by intent. People don't kill their husbands and wives unless there's just this huge amount of emotion involved, unless they're like a mafia hitman. You know, mafia hitmen are the perfect example of someone who kills with premeditation and intent. Most killings that you read about in Wyoming where it involves another family member has to do with huge, uncontrollable emotions, which is a manslaughter charge.
Well,
period.
the other problem with this statute is it doesn't apply to children. You know, we had a case out of Cheyenne where some children conspired and shot their father because he'd been battering them and their mother for a long time, and this defense wasn't in effect then. But even if it had been, it doesn't protect those children. It didn't give those children the same rights that their mother would have had in raising this defense. And I think that's an anomaly that the Wyoming legislature or the Wyoming courts need to fix.
Well, do you think that the legislature should establish the mitigating circumstances and remove the minimum penalty of 20?
Oh, well, yes.
Sentencing-wise, Wendy Trusky would have probably been better off to have been convicted of first-degree murder.
Well, I
because
think
there is no minimum sentence on hers.
The court can suspend part of a 20-year sentence, I believe, under the old Peterson case, which was the murder case.
It's very rare that that's ever done.
At the Reef here in Casper a long time ago, Judge Lineback, when he was in private practice, tried that case and very ably convinced the Supreme Court that even with a 20-year minimum sentence, that the court can suspend a portion of that sentence, and I think that that may be appropriate in the Trusky case. In other words, there may be some mitigation that can be raised about that case, and if the judge over there thinks that it's appropriate, he can impose a 20-year minimum sentence and then suspend part of it.
See, many times a person gets convicted, though, of what they did after the killing or the shooting. In other words, the burying of the guy and the hiding of the evidence and the absconding from the jurisdiction, people take a look at that and think, boy, that indicates something, when all of that is just total fear and a person's mind raging out of control. What you have to look at is what happened at the precise moment the killing occurred, not what happened later, not what somebody did out of getting bad advice or not understanding or having their own mind psychologically unwinding, you know, like a top. Take a situation where some father is sexually abusing a daughter, and he sexually abuses her for years. And finally one day he comes in and he's going to do it again, and she's fed up and she shoots him. The juries would convict a young woman like that. Said, well, he wasn't trying to kill you. Self-defense, you can only use self-defense in a situation where you believe that somebody's trying to kill you. Now, our law is void of protection for women who may have to kill somebody because they're being sexually abused by a family member.
Well, I'm not sure that all juries in all circumstances would convict under that kind of a scenario, Dallas. I think that would depend a lot on the prosecution and probably more importantly the defense lawyers, and the defense witnesses. But that type of situation would not have the benefit of this battered woman syndrome defense that's been passed by the legislature.
Exactly.
Okay, that's the part I think the legislature needs to fix.
Let's do a hypothetical. I am a battered spouse. I am at my wit's end right now. I don't know what I'm going to do. I know I can't take this anymore. What do I do? I don't want to give people the recipe on how to kill people.
Call 911, call the self-help center, call DFS, call for help. The self-help center doesn't charge for their services. They don't charge for their shelter. They don't charge for their counseling. They're there to help people. And they've helped a lot of women escape violent families. They've helped men escape violent families. And more importantly, to me at least, they've helped hundreds of children right here in Casper escape violent family circumstances that may have led to someone being much more seriously injured.
Family members who know this is going on needs to report it. You can't sit there, children and ladies and men, you can't sit there and continually witness this problem. You have to turn it in. Otherwise, you have these terrible things that have happened to this trusty family, which can never be repaired. You have to change this. You have to call 911. You have to call the sheriff. You have to call the police. You have to do what is necessary to stop this terrible abuse, period.
The cycle of violence continues. The learned helplessness becomes more and more ingrained if there's not someone calling every time one of these instances happens. And children out there, if you see your mother and father fighting and it gets physical or it gets violent, call 911.
What else can they do? Can they tell a teacher? Is this a way for kids to go?
Teachers aren't required by law to do anything about it, though. Teachers are required only to report abuse to the children, not abuse within the family. And so I think it's good to talk about it with teachers, but it's more important that you contact the authorities.
Well, it's pretty awesome, though, if you're a kid, to turn your mom and dad into the cops. How about a family minister, somebody you trust?
Anybody who knows it needs to take steps to stop it. Now, the problem you have is there are people that we've represented, Frank and I both. I represented a lady who shot the guy she was living with years ago. The coroner's jury ruled that it was self-defense, was before the battered woman syndrome case. The point of it is that this woman turned this guy in several times, and the police would come out, he would lie his way out of it, he would threaten her, nobody would do anything to the guy until the final ultimate result. The fact is that the authorities have to do something when these complaints are made to stop this trend of abuse that goes on for years and years and years and finally results in family members killing each other. It's the most terrible kind of thing that can happen to families.
Well, and this is a very vicious cycle. You know, Nicole Simpson reported her husband numerous times before someone finally killed her, and we all think it was you, O.J., and nothing happened to him. In other instances, right here in Wyoming, women have reported their husbands over and over and over again, only to have the husband get out from under it each time, in many instances with the woman's help. Because husbands, after they batter their wives, generally become very remorseful and do all sorts of things, financial, emotional, and otherwise, to try and win back the woman that they've beaten. And that's part of this cycle that Dr. Lenore Walker talks about in her book on battered women, and it's part of what causes this learned helplessness, is this constant reporting, getting little or no help, and then getting back together with husband because he begs or pleads or whatever he does. You can't afford to live by yourself. In those circumstances, that cycle continues. The learned helplessness becomes greater. The battering instances become more frequent. They become more violent. And that's how we get to this syndrome. You know,
I had a person tell me one time in a case where they were confronted with their own death and they took matters into their own hands, and the person told me very frankly, they said, you know, I'd rather be judged by 12 than carried by 6. And what happens is you get the reverse. We've had 2 cases in Natrona County in the past couple of years where men have beaten their wives and killed them, and then went to bed and then woke up and found their wife dead in bed or laying on the floor. And so, you know, if that woman would have shot that guy and killed that guy, guess what would have happened to her, Frank? She'd have been charged with first-degree murder.
Same thing that happened to the husband.
And then the jurors would have all said, well, but he didn't kill her. Well, you know, what about the situations where these men do kill these women and they beat them until they're dead? And all I can say is that it's a terrible, terrible crime. It's a terrible, terrible thing for families to go through. And the only answer is that for the families to become aware, there are signs, the children, the way they act, the teachers can observe things, the police can investigate, but there has to be more of a community effort to do something.
Is there more of an awareness and a sensitivity now in law enforcement circles that it's not just the good old boy club like it was 15, 20 years ago?
Well, sure. At the Wyoming Law Enforcement Academy now, and in every, at least theoretically, in every law enforcement agency in the state now, there's special training about this Domestic Violence Act that's been passed by the legislature. The county court and justice court judges are trained in how to handle family violence matters, and interestingly, these family violence matters are the most dangerous situation into which law enforcement officers can place themselves, because they are so emotional and become so violent. You know, there's a lot of circumstances where police are called to a family violence situation, husband beating wife, they show up to arrest husband, and wife goes off on him because she doesn't want the husband to be hauled off because he's the one who buys the milk and bread for the kids. And so it's very complicated and very difficult, but law enforcement agencies are becoming much more aware of the situation, and they have the ability and the authority now to arrest instantly, to remove one or both of the parties from the home. They now know to take women to the social service agencies, including the self-help centers that can help them, and they've been trained to do that, and I hope they're doing it.
The one thing I want to leave you with as this Report to Wyoming concludes, if you need help, call somebody. The Self-Help Center, 911, your minister, let someone know. Thank you very much for joining us. It has been a very legal kind of week around Wyoming and around the U.S. with Monica Lewinsky firing attorneys and hiring attorneys, and Keith Jesperson copping a plea, and the Jean-Benet Ramsey Task Force meeting. So we decided it was time to bring in the legal team for Report to Wyoming and get their rather unique viewpoints on things. That's coming up next on Report to Wyoming. There was a big surprise in Wyoming this week in legal circles and for everybody. The happy-faced killer, Keith Jesperson, has decided to cop a plea, as they say. So we are joined today by Frank Chapman and Dallas Laird, our legal team here on Report to Wyoming. That will be one of the topics that we will be talking about today. Gentlemen, was this a big surprise to you that we brought him all the way back here for the death penalty and now he cops a plea?
No surprise. I mean, we brought him back here because he murdered a girl. He confessed to it. The fact that he was incarcerated elsewhere shouldn't stop the state of Wyoming from vigorously prosecuting murderers. And I don't think anyone's disappointed with the plea. I'm sorry that he didn't get the death penalty personally, because I think under the circumstances that he's lived and confessed to, that he was a perfect candidate for it.
Well, I'll tell you, I think it was a waste of money. I don't think we should have done it. I think it was an exercise in nothingness. I mean, yes, I agree with Frank that you should prosecute murders, but the guy's doing time for a triple homicide in Oregon. He's in the pen for the rest of his life. We can put what we call a detainer on him. There's no statute of limitations for crime in Wyoming. If he were to ever get out, he wouldn't have gotten out. We could have brought him back then and done it and spent our money if we needed to. But I think Wyoming people think, you know, you only ought to spend money if you need to spend it on things like that. I think it was just a big exercise in futility, and it had a lot to do with politics and had very little to do with anything that made any difference in anybody's lives.
Well, homicide's important, and anytime there's a homicide in this state, it ought to be prosecuted. The only thing now that Wyoming has ensured is that Mr. Jesperson is never going to get out of jail. He probably would have never got out in Oregon. The other thing that this conviction may help with somewhere else is if a state who exercises the death penalty more vigorously than Wyoming gets a hold of him, they'll now have this conviction to refer back to along with those out of Oregon.
Well, I suggested to you that one time that they should just send him to Texas. That's where they get rid of people. But Frank, it's timing. I mean, why do you have to bring a man back now and do it now when you don't have to do it now?
Because
you only have to do it.
He murdered a girl.
But it's
here in Wyoming, and when you murder girls or men or boys or ladies here in Wyoming, you need to stand up for it, and you need to be punished for it. That's why he was brought back.
Well, I don't disagree with that, but I'm talking about the timing of it and the necessity for it and the expenditure of time and money on it when it wasn't necessary. All we did was we ran him through our system and sent him back to Oregon, which is where he would be if none of this ever happened in the first place.
If we hadn't brought him from Oregon, he'd be on the internet now bragging about having killed a woman in Wyoming and gotten away with it.
He'll be doing that anyway. I'm just saying.
He won't say he got away with it now.
I'm just saying it was a waste.
I'm comfortable with spending money to prosecute people under those circumstances.
It's a waste of time and money. If it was a matter of him getting away or getting away with it, or something happening where he could get out of jail now, yes, I agree with you 100%.
Let's talk about the money then, okay?
But three life
the
convictions.
The County Attorney gets paid the same salary whether he prosecutes Mr. Jesperson or not. So does his assistant.
Well, but he took him off the hook. He took him off the hook because he pled guilty. We didn't go through.
Gets paid the same amount salary per month whether he defends Mr. Jesperson or not.
If we would have gone to trial,
these costs that are projected here for
it's because he pled guilty.
Are inflated.
It's because he pled guilty. He made nothing out of nothing. He pled guilty, and so nothing happened except going back to Oregon. Now, if he would have said, no, I want a trial, and they went through all this and asked for the death penalty, and then spent $3 million and waited 12 years while he was up in Oregon, and we'd all be retired by then, nobody would have even cared except we'd have spent $2 or $3 million. We could put in the school systems. Let's put the money in the school systems.
We didn't spend $100,000 convicting Keith Jesperson.
Well, he pled guilty.
It didn't take that much. It wouldn't have taken that much more to convict him at trial.
It was enough money to buy some computers for some kids in a school that could have used it now.
Well, I think you need to take that up with the legislature. If we're going to talk about school funding, there's a lot of things that could have, should have, would have been done.
Let's give teachers a raise with that money.
I don't object to that. My wife's a teacher.
See how I know how to get him to agree?
Do you think that it was the threat of the death penalty that caused him to change his mind and decide to plead guilty, or did he just get bored because he pled out in Oregon?
No, I think it was the threat of the death penalty, and I think it was the threat of that death penalty being enforced here. You know, if he would have gone to trial and been convicted, I believe firmly and sincerely that he would have received the death penalty. And obviously he has a lot more respect and caring for his own life than he did for all these kids that he murdered across the country.
See, I think the real truth, though, Wes, is that the prosecutors knew they didn't have a very good case, and they offered him this deal a long time ago. So if they offered this terrible murderer this deal, and dropped the death penalty, something must have been wrong with their case in their minds for them to have gone through this whole exercise and then said, here, we'd like to offer you a deal, which means nothing because you're going to be gone anyway. If you really feel like you're committed to a situation and where this guy is this terrible, evil murderer, which apparently he is, and then to let him off the hook like they did makes no sense to me.
Well, they didn't let him off the hook. They convicted him of first-degree murder. He's going to have a life sentence as a result of that, and that's a lot more than nothing.
That's all that is like giving Dennis Rodman